Good morning. A warm welcome to the Humanist community in Silicon Valley's Sunday Forum, to those who are joining us on Zoom and to those joining us on Facebook. My name is Senna Havasi. I'm a longtime member. The Humanist community is a chapter of the American Humanist Association. Humanist is a secular and reality-based philosophy of life that affirms our ability and responsibility to lead ethical lives of personal fulfillment that aspire to the greater good. We value freedom, health, happiness, fairness, compassion, and using science and reason to acquire and apply knowledge. If these words describe your thinking, we invite you to become a member of the Humanist community if you have not yet done so. Membership forms are available on our website at humanist.org. A special welcome to those who are with us for the first time. We invite you to continue listening to our weekly forum and other events. You can find all our events listed on the website, humanist.org. Please aid us in continuing to present these forums by donating to the Humanist community. You can find out how to donate to our organization on our website, www.humanist.org. Question and answer will follow the presentation. Oh, here we go. Our speaker today is Leland Chan, Adjunct Professor of Law at Golden Gate University. He graduated from UC Berkeley School of Law and served as longtime General Counsel of the California Bankers Association during his legal career. The topic today is how the Supreme Court works.
Well, thank you for the opportunity to speak to you about this topic. It's going to be a little bit more spicy than just bland title, how the Supreme Court works. I'm sure that I'll generate some responses at the end, but let me give you an idea of what we're talking about today. So we're going to have an exercise in comparing judges with baseball umpires as a groundwork for figuring out, what judges do, why they do what they do. We'll focus in on a case study about the rise and fall of abortion rights. Abortion rights are created by the court and then eliminated by the court. Why are they doing that? Ask the question, are conservatives the new judicial activists? And I'll start concluding by saying that, well, judges actually aren't not like umpires, and I'll talk about why. And then end up with the question, is the Supreme Court out of line? Which I think that a lot of people think they are. All right. If anybody has any questions, you can either raise your hand or wait until about half an hour. That's how long my presentation will be. I'll be glad to answer afterwards as well. I won't be able to look at the chat live, so if anybody wants to alert me to a question on chat, feel free to do that. Okay. This is Chief Justice John Roberts. When he was confirmed, he famously made the comment that he's not there to make policy. He's not there to try to push his own agenda. He says that he's going to be like an umpire, right? He calls balls and strikes as he sees them in an impartial manner. So let's look at that analogy and see if that works. So an umpire has certain rules, right? They just call balls and strikes. If you don't know baseball, it shouldn't matter. I think I can make this pretty straightforward. So let me ask a few provocative questions. We have the A's, we have the Giants, for example. Can an umpire who is secretly, let's say, an A's fan, decide to give the A's players 4 strikes instead of 3 strikes for the Giants, right? And why would he do that? He may say that the A's budget is much lower. So, hey, this is fair. I think this is a fair way of doing it. Does anybody agree that that would be a good thing to do or a correct thing to do? Could the A's lobby a judge to do that? I think the answer is clearly no. I don't think anybody would say that's a good idea. no matter how justifiable this particular umpire thinks that this is a good argument, right? The A's are known historically for being, or the players are for being underpaid, and yet they pretty much overachieve. Okay. All right. Next question. Can an umpire favor an Asian player because Asians are 12% of the population, but hey, they only represent less than 1% of the major league players? I made that up, frankly, but that's probably true. Is that something that you can lobby an umpire to do? Or is that something that an umpire can do on his own? They're still all males, because the umpire thinks that's a good thing to do. Again, I think the obvious answer is no. Um, uh, could there be such a rule? Yeah, it could be. But who would write that rule? It would be Major League Baseball, right? Right. Whoever runs the organization, they can run it however they want to. If they want to create such a rule, they can do that. But you certainly would ask a judge, an umpire to do that. My last question is, can a judge revive the quote, one bounce rule, which actually had existed at one time? And that was a rule when a fly ball that was caught after one bounce is considered an out. Why would they do that? Because back then they didn't use gloves, and it was considered to be dangerous and too difficult to catch a fly ball on the fly. So if you caught it after one bounce, then it's an out. So can you ask an umpire on a particular game to say, hey, let's apply for this game only the one bounce rule? And again, this is a policy decision that Major League Baseball would do, and not a judge, right? And because, for one thing, umpires basically follow the rule; they don't make the rules. Okay, so what do we know about umpires? Their purpose is really solely to interpret and enforce the rules, right? Major League Baseball, the owners or whatever entity responsible for Major League Baseball are the ones that write the rules. Umpires are neutral; they don't play favorites. They comply with rules that are very narrowly written, right? There's not much space for an umpire to interpret. You can say that the strike zone is something that they do interpret. That's true, right? The ball has to be midway between the shoulder and the belt, somewhere around here, and the ball has to travel within the width of the plate. That is a very clear rule. Sometimes they may say they may have a high strike zone or low strike zone. Fine, but that's about as much interpretation as they are given. And finally, umpires play no role in the fairness of the game, right? I think that beyond being a neutral caller of balls and strikes, you can say that there are a lot of things about baseball teams that are unfair, right? The New York Yankees has oodles of money. The Oakland A's had very, very little money. That's not fair. But nevertheless, the umpires are not responsible for making it fair, other than being a neutral umpire. Okay, I hope that offers a clear example of what umpires do. And the question on the table still is, are judges like umpires, as Judge Roberts says? So how are they different? Okay, this is a bit of basic stuff. All of you are very experienced and knowledgeable people. I apologize for this being so pedestrian, but we need to start with some basic principles. The first is that the legislative power in the Constitution is delegated to Congress. It's delegated solely to Congress. Nobody else shares it. Courts don't write policy, right? Courts only interpret. That's what Article 3 says. And I want to also add in that Article 6 says that the Constitution and the laws of the US are the supreme law of the land, meaning that the Constitution creates a hierarchy of which laws are above which. So the Constitution actually rests at the top, and any conflicting congressional laws, for example, have to be consistent with the Constitution. And also state laws have to be consistent with the Constitution. as well. So that creates something a little different from what we already saw with baseball, right? In baseball, the umpires follow a set of rules, and there are no superior rules and lesser rules that the umpire has to try to see if there's any conflict. Okay, so let's take this to a specific example. In 1973, as you know, the right to abortion was created. So a question is, how was it created? Where did it come from? Let's look at what happened in that case. So we have a woman, Norma McCorvey, who was named in the case uh, uh, Jane Roe. And the question before the court was, can she get an abortion? She lived in the state of Texas, and what was the rule that the court would apply? And this is trial court. This is when Norma McCorvey first went into court, and she wanted an abortion. Where did she live? She lived in Texas, right? So she went to a Texas court, and the court, being like an umpire, right, says, well, what's the rule? And the rule was, well, Texas bans abortions. That's rule number one. So the result of applying this rule is that, well, Miss Rowe lives in Texas. She wants an abortion. Texas law does not allow abortions. Therefore, a judge is certainly not going to say, but I think that's a bad rule. He just says that you can't get an abortion. That was the conclusion. So it's fair to ask, well, what could Miss Rowe do, right? Well, it's not a great answer, but what if the people of the state of Texas thought that a ban on abortion was bad policy, then the people of Texas would normally go to the state house in Austin and try to lobby their legislators to say, this is a bad rule, we should change it, right? Going to the judge and asking the judge to change it is kind of like the A's going to the umpire and asking for 4 outs rather than 3. But what happened at the Supreme Court? The Supreme Court applied rule number 2. And it said that the Constitution recognizes a personal, quote, privacy right and a liberty interest in preventing government from interfering with a woman's abortion decision. So it really bears asking, well, where did the Supreme Court get this from? Does, for example, the concept of abortion exist in the Constitution, right? Because under the Constitution, judges actually don't have the ability to make policy. They only have the prerogative, which is a very big prerogative, to interpret the Constitution. So where did this idea of abortion being a personal right under the Constitution come from? So so basically looking at the Supreme Court's analysis, they said, well, one premise is that, I'm sorry, this is comparison now. If you have a premise of Major League Baseball rules are silent about favoring Asians, right? Now I'm comparing the Roe decision with this idea of favoring Asians in baseball. If Major League rules are silent about favoring Asians, and then the premise 2 would be the Major League Baseball umpires can only enforce the rules as written. The conclusion clearly is that umpires cannot favor Asians, okay? And yet the Supreme Court faced the same situation, right? The Supreme Court faced a situation in which the Constitution was silent on the issue of abortion, and yet it did recognize abortion as a right. So where exactly did this idea of abortion in the Constitution come from? Well, it came from the Supreme Court's prior cases, right? This right of privacy, for example, here on the left, this case, Griswold versus Connecticut, was a case in 1965 in which the Supreme Court ruled that the state of Connecticut's law that banned the use and advocacy of contraceptives was something that was protected by the Constitution. How did they get that? Well, they cobbled together various provisions of the Constitution, talking about liberty, talking about a man's person is his castle, the right of conscience, and so forth. And all that comes under what is called a penumbra of the idea of privacy. So the Supreme Court recognized the right of privacy to strike down a Connecticut law. Similarly, in Loving versus Virginia, this is the case in Virginia in 1967, that in which the state of Virginia prohibited interracial marriage, anti-miscegenation laws. And the court there said that, again, the Constitution protects a person's right of liberty, right, including to get married. And so from that foundation, when the abortion case came up, the court relied on its own interpretations of contraception, interracial marriage, to say that, yes, the Constitution also protects a woman's right to have an abortion. Okay, so this string of decisions and just a number of other decisions were decided back in the 50s and the 60s into the 70s, in which the Supreme Court seemed to be creating novel ideas as to what is in the Constitution, right? So the question, I think, is a fair question, and we're not trying to be partisan or advocating one side or the other, because in the moment I'll be talking about conservatives. So the question is, isn't this like the A's, the umpires favoring the A's because the umpires think it's fair? In other words, is the court basically inserting its own values by saying that I think that Constitution protects the right to an abortion, right? Is this the instance of judges being super legislators? Now, at this time, again, the 50s, 60s, and 70s, beginning with the Brown versus Board of Education decision, the court was dominated by liberals, right? It's called the Warren Court. Errol Warren was the governor of California. He was picked by Eisenhower to sit on the Supreme Court. And Eisenhower famously referred to Earl Warren as his biggest mistake during his presidency, because he thought that Earl Warren was a conservative. It turned out that he presided over the most liberal court in decades. And that Warren Court decided many, many things that were not viewed very friendly by conservatives. So this is the backdrop of the creation of the Federalist Society. Some of you may have heard of that. When I went to law school in the mid-80s, the Federalist Society was pretty new. As I recall, there were about 8 members in my school, but they became very powerful, as you know. And today they have been successful in inserting a good number of the judges, all of whom are conservative, not only onto the Supreme Court, but also to the appellate courts and federal district courts. So what was the Federalist Society about, and why did they come about? Well, one of their main objectives can be summarized in this quote that says, "It is emphatically the province of the duty of the judiciary to say what the law is, but not what it should be," right? In other words, their ideal, as articulated by Judge Roberts, is that judges ought not to play favorites. They should interpret the law, and even if they should decide that they would prefer the law to be a certain way, it is not for them to decide, it is for the legislature to decide. So taking an example here, if the Lovings, Mr. and Mrs. Loving, didn't like the law in Virginia that didn't allow them to marry, they can't go to a judge to ask the judge to overturn the state law. They have to go to Richmond, the capital of Virginia, and try to lobby the state to change its rule. That's what, in essence, what the Federalist Society says ought to happen. But then let's look at what happened since the mid-80s when the Federalist Society was formed. and what they did. So now we have the Roberts Court, and in this slide, which I call the conservative strike back, what did the conservative justices do when they had the power? Did they refrain from inserting their individual preferences when they decided the laws? Well, you can decide. Here are 4 or 5 examples that I have of the cases that have been passed in the last 15, 20 years. The first one I have is Hobby Lobby versus Borough. Excuse me. This is the case in which the Supreme Court made a decision that corporations have religious rights, right? So for-profit corporation, Hobby Lobby was a for-profit corporation. It has stores all over the United States. And what they sued the Department of Health and Human Services about was they opposed the idea that the Obamacare required corporations to offer health care that included contraceptive coverage for women. They argued that we are a closely held corporation, so the family that owns a corporation has religious rights, and a corporation is merely a collection of people, and people under corporations have religious rights. Even though corporations are nothing more than legal entities, they are created by the state by a law, and traditionally, they have never been seen to be enjoying the rights of religion as persons do. So here we have Hobby Lobby going to the Supreme Court and arguing that, hey, we think that corporations ought to be treated like people for purposes of religion, right? This is a novel argument. It's not in the Constitution. The Constitution has never been interpreted to offer corporations to have religious rights. And yet the judges in this case said, we like that idea. We don't find it in the Constitution, but we're going to give it to you. Let's look at the next case, Citizens United versus FEC. This is a case in which the court said that, again, for the first time, that corporations actually have a sense of a free speech right under the Constitution. And that led directly to the establishment of unlimited spending on so-called independent expenditures for political campaigns. And there are no dollar limits on that. We talked about the abortion decision. The Supreme Court recognized the abortion right in 1973. And then in 2022, it unrecognized the right to abortion. And so, again, we have to ask this question, why is it that these momentous decisions are made by essentially umpires rather than policymakers? Oops, and I think I have the wrong picture here, but my last example is the Second Amendment. This is not US versus Trump, but rather DC versus Heller. In that case, again, for the first time, the Supreme Court decided that the Second Amendment protects individual gun ownership, even though for the past 250 years, nobody has ever recognized that the Second Amendment recognized gun ownership. Again, is this the case of umpires rewriting the rules? So I've given basically a bipartisan, if you will, criticism of what judges are doing. You know, in both instances, the liberals and the conservatives appear to be interpreting the Constitution in ways that they are personally inclined. In some ways, they are writing policy for the United States, even though they themselves are non-elected, and even though they're not supposed to be inserting their own values onto America. And you have to appreciate just how powerful this power that they're exercising is, right? When under Citizens United, the Supreme Court can say that we disagree with the Feingold McCain campaign finance law that prohibits these kinds of expenditures, we basically, the court, override all of Congress, right? The House passing a bill, the Senate passing the bill, and the president signing the bill. 5 justices can say, we're going to undo all that and say, we think that you cannot place these restrictions on corporations and labor unions, right? That's a powerful, powerful authority that the court is exercising. Moreover, when it appears that the court is basically interpreting the Constitution in ways that doesn't appear to be written in the Constitution, they are essentially amending the Constitution. And that is even greater power because in order to amend the Constitution, you actually need 2/3 of the legislature, the House and the Senate, to pass a measure, and then 3/4 of the states in order to affirm an amendment of the Constitution. So, for example, when the Supreme Court declared that gay marriage was a constitutional right, what the court is essentially doing is to rewrite the Constitution, amend it to say essentially Congress shall make no law abridging the right to free speech and to marry as gay persons. That's a very, very powerful thing to do whenever the Supreme Court interprets the Constitution in a broad way. So we come to the kind of concluding resolution of this dilemma, right? So are judges just imposing their own values, right? Never mind is the conservative judge or a liberal judge. In my examples, are the judges simply acting like super legislators, policymakers, unelected? And so here's the resolution. The short answer is that, well, the Supreme Court is actually different from normal judges. If we're talking about a judge like Judge Judy, or any trial court judge, or even appellate court judge, it's fair to say that their roles are very, very similar to that of an umpire, right? If you're a trial judge, you're not going to be making constitutional interpretations. You're merely going to look at what the appellate courts have decided and what the Supreme Court has decided. And whatever they have decided, they will follow that rule, right? It's a little broader than calling balls and strikes or the definition of balls and strikes, but trial courts and appellate courts basically stay within whatever the interpretations there are. The Supreme Court is very different. The Supreme Court has given itself the power to interpret the Constitution and to say essentially that the Constitution is what the Supreme Court says it is. And there's no further appeals process from that. So the Constitution is not a rule book, right? It's not like this is the definition of a strike. The Constitution includes very many concepts, right? For example, what is liberty? What is due process? What is free speech? What is equal protection, right? What is unreasonable search and seizure? All of these are concepts. And it is inevitable that a judge has to interpret what that concept means, right? So there's no getting around that the Supreme Court has to interpret these things. And when they interpret it, of course, this becomes a controversy. When they interpret it, are they going to go back to what the originators, the writers, the originalists, the framers said what it means? Or do you try to apply it some way to modern situations, right? For example, if you're talking about a modern device that a police officer can place on a person's car in order to track that car's movements, or to look at metadata to see where the cell phone is when you used it to commit the murder, is that an unreasonable search and seizure? If you look at the originalist position, you say, well, no, there's no such thing as these items back in the day, 1787. So we're silent about that. We have to, we don't know what that means. Or you say, well, what does this unreasonable search and seizure mean today? this is probably what it would mean, right? Those are two different ways of interpreting. But regardless of which way you use, it is inevitable that a judge has to decide how they would to interpret these concepts in the Constitution. The Constitution is the supreme law of the land. Again, it is inevitable that certain parts of the Constitution or congressional laws would be superseded by the Constitution. Even within the Constitution, there are certain parts of the Constitution that override another part of the Constitution. For example, the First Amendment, right? Yes, Congress has the legislative power, but the First Amendment actually puts restrictions on that power. It says Congress shall make no laws abridging the freedom of speech, for example. Okay, so because of that, the judges have to interpret those occasions in which an act of Congress actually is invalid because it violates the Constitution. As I said, the Constitution means what the court says it means, and not the Congress. The Constitution is actually not what Congress says it is, and the Constitution is not what the president thinks it is, right? So you might think that, wait, if the president sees the bill that Congress has passed, and let's say the president has signed it, the president later on cannot say, well, I'm not going to enforce this law because I think it's unconstitutional. The president doesn't have that ability. Congress cannot say that we think that the law we just passed is constitutional, even if it clearly violates the Constitution. Say no, because Congress has too much of an interest in it. They're conflicted out. They have a conflict of interest. Of course, they'll always say that what they pass is constitutional. That question is for the court to decide. So in that sense, judges, the Supreme Court judges, are different. So that's really my conclusion. Yes, the Supreme Court at times seems to be lawless in the sense that they seem to be inserting their own opinions on their cases that they decide rather than just applying the laws. I'm not saying that doesn't happen. It does happen, but the Supreme Court, one of the good things about the Supreme Court is that they have to show their work. They actually have to write their opinions and not just say, this is my conclusion. They have to show the work. They have to argue why they think that this particular decision is something that is justified rather than this being my opinion. So that's very broad, I realize. I'll be very, very happy to drill deeper in any of these cases or other cases that I mentioned if I know about it. And I'll be glad to take questions about this now. I see there's a lot of chats. So if somebody wants to moderate delivering the questions to me, I'll be happy to answer them.
Can you see the chat window?
I can actually. Do you want me to just read it?
All right.
There are no questions in the chat. They're just references people can look up.
Oh, okay.
No, I vaguely remember in an old history class, they comment on the first time the Supreme Court ruled that a law was unconstitutional. This kind of shook people up at the time. Do you remember what that incident was? Not that you were there, but you may have read.
What was unconstitutional?
Yeah.
I didn't hear the question. What was found unconstitutional?
I don't know. That's what I'm kind of asking.
First time. He doesn't know what we're talking about. The first time. You said the first time?
The first time?
Yes, the first time.
Yeah, you're referring to the famous case called Marbury versus Madison. And it's a case that is fascinating, but it takes about 5 minutes to kind of set it up. But that was the first case in which the Supreme Court under Justice John Marshall struck down a law and it said, and a lot of the principles that I just mentioned was derived from that Marbury versus Madison decision. It was the first time in which the court said, we the court, have the ability to say that an act of Congress does not comply with the Constitution, that violates the Constitution, and by doing so, strike that law. Strike it as if it had the veto power.
What year was that?
What year? It was 1803.
Okay, thank you. Helen?
That thing about the Federalist Society really sticks in my craw because the current Supreme Court is saying what the law should be instead of what it really is.
I think that's a fair.
It's six in particular.
It's a fair accusation. The way I respond to my students in this situation, if you were my students, I would say, well, does the fact that the court ruled that abortion was in the Constitution, that gay marriage was in the Constitution, does that stick in your craw? If not, why not? It's a very important question because the larger question is, do you like the idea that judges can insert their own values into the case regardless of what the Constitution or the laws say? And if you say, no, I don't like that, that's a very principled position to take. But then you cannot then say, well, I like it when Ruth Bader Ginsburg does it, but I don't like it when Justice Scalia does it. Now, that's also a principled decision or position, but that's more utilitarian, right? That's saying, well, if the judges do the things that I like that are unconstitutional or appear to be unconstitutional, that's okay. When they do things that I don't like, then that's not okay. Because we have to step outside of ourselves and say, well, were I a conservative, then I think that these strayings by the judges are okay because they're doing a good thing by my book. But if I'm a liberal, I would say, no, that's awful because I don't agree with those morals. That's fine. That's fine. But you have to ask yourself, are you going to apply this principle generally and say, judges stay out of it, right? Let the policymakers make their policies. Judges don't make their policies. That's fine. But then you have to live with the idea that perhaps Roe v. Wade should not have been made, or Obergefell should not have been decided the way it was, and so forth.
Okay, Zen?
Yeah. Thank you, Professor Chan, for agreeing to give the talk. I have a question about showing your work. Can you talk about the shadow docket a little bit and why it exists and how it exists?
There's two different questions. The shadow docket refers to a less than opaque, or excuse me, an opaque way of accepting and then resolving decisions. That's perhaps it's not that open to scrutiny. So normally the way that the court decides to accept the case is that you have to have at least 4 of the justices decide that they will take a particular case, because there are literally thousands of cases that go up on appeal, and the Supreme Court has been accepting 60.
Waiting room.
Yeah, very few cases. So they have to decide which ones to take. And again, a vote of 4 justices will let a case go up for them. And then they have to have briefings and then oral argument. And then when they have their opinions, they're really long, and they have to basically write down the reasons why they are deciding the way they are. That's what it means by showing their work.
So just to follow up, so it has to do with which cases are accepted to begin with and not how they're adjudicated.
That's not, well, yeah, the first part says how they're accepted, yeah.
Yeah, okay.
The shadow docket basically refers to some way of accepting and resolving a case that is inconsistent with that way of doing it.
Oh, okay. Now I'm confused. So it's not just a question of whether or not a given case is heard to begin with, or is it?
So a shadow docket would be something like, and I don't really follow this very closely, but for example, a case goes up to the Supreme Court, somebody doesn't like it, and a single justice might talk with, the judge below and say, I think this should be done this way, or let's dismiss it or something like that. It's a very informal way of resolving a decision.
Okay.
That's the shadow docket.
Okay, thank you.
Mm-hmm.
Is that binding on other courts?
Yeah, it gets a little complicated, but it's binding in the sense that that resolution of that case was resolved a certain way that has precedential value. Yeah.
Okay. Yeah, I think there's a general impression that and I may be wrong, that the members of the Supreme Court are not typical of the attitudes of most Americans. Will you comment on that?
Well, it depends on the time. So a question would be, is it legitimate to say that the majority of the Supreme Court ought to reflect the values of most of Americans? Okay. So in some ways, that's kind of what you're asking. So I'll kind of ask that back. Okay. So the Supreme Court, for example, says that essentially, you can't discriminate against a person based on their race. Okay. Suppose there was a law in the United States that actually does, Congress passed it, right? Into the political process, meaning in concept, it's by majority. And they passed a law that says that Chinese people are not allowed to support China publicly. Okay. Chinese people are, as I said, I think maybe 12% of the population, minority, right? But let's say that the majority of the US actually favors this rule. So, should the Supreme Court be consisting of, at that time, the majority of which actually favors discriminating against Chinese? Right? One way to answer that question is no, by purpose, by construction, by intent, the Constitution, at least the Bill of Rights, is intensely anti-majoritarian, right? If a single person says my free speech rights are opposed by this popularly enacted law, if it violates the First Amendment, that one person can overcome the will of the majority, right? If that's the case, do we really want the court merely to reflect the sentiments of the majority of the people? What if the majority of the people are eventually, God forbid, all Trumpers? Okay, then should the Supreme Court consist of basically Trumpists? And you can say the same thing about the liberals. So I would say that no, the purpose of the Supreme Court justices really is solely to interpret the law, just like the archetypical umpire concept, except as we know that the Constitution is much more complex than that. Does that answer your question? It's kind of a roundabout way of answering that question.
I don't see any response. Jerry.
So the court's supposed to only interpret the law, but there's ambiguity.
Absolutely.
The Constitution, when they wrote the Constitution, was a different world than now. So, things are going to evolve. It's going to be complicated.
Yep.
Over time, you have these liberal biases, you have these conservative biases, and it would really be nice to have an unbiased system. But it seems to me, as long as humans are making decisions, and humans are less than perfect, and humans have biases, you're going to have biased decisions. Now, some people might argue, well, let's let the AI do it. But the AI, I believe, also has the bias of the humans. There's no way you're going to get this right.
Interesting idea, AI. Yeah.
Okay.
But here's the rub, though. If we put the shackles, if you will, on judges to say that they should only interpret, right? So in other words, the analogy being, if Major League Baseball rules are silent about Asians, then the umpire should never make a rule on its own about Asians, right? 4 strikes rather than 3. So if we have, for example, gay marriage, and if the only way to allow gay marriage is not for judges to say, we think the Constitution means this, even though it's a stretch, but the only way to do it is through the amendment process, right? To actually put gay rights into the Constitution, I would say that it will never happen. Not never happen, but it will be so rare, right? Just think of the Equal Rights Amendment, which still hasn't passed, right? So if we say that yes, judges just shouldn't be biased at all, if the Constitution is silent, you say, well, I'm sorry, I'm not going to change the rule because I'm just a judge. Let the political process work. I'm saying that there probably will never be, quote, progress made in this country because we just cannot get together in 2/3 of the legislature and 3/4 of the states to do any big thing.
Okay, Musuma.
Yeah, I have a question about what does the Constitution say about the formation of the Supreme Court and how the judges will be elected? And also, since the population shows that 50%, more than 50% are women, why the Supreme Court has mostly dominated by men and giving rule policies related to women?
Well, that's just an empirical question. Why is right now there's 4 women on court, 5 men. It's the most ever. I would say just provocatively, there's many ways to talk about this, and we can feel free to talk about it if we want to. We know that the judges are nominated by the president and confirmed by the Senate, and so whatever the president decides to do in terms of nominations, that's within that president's prerogative. Secondly, and this is kind of an idealistic way of looking at it, but in some ways, in some Platonic ideal, it shouldn't matter the gender, the experience, the orientation, the political views of a judge, right? In the same way that umpires ought to be, their main virtue should be neutrality, right? You cannot corrupt an umpire. You cannot say, hey, can you call the strikes a little more narrowly for me, right? You're not supposed to be able to do that. So we shouldn't, I don't think that we should fall into this somewhat experimental view that the only way for a woman to have justice is to have a woman on the Supreme Court. The only way for a Black person to have justice is to have a Black person on the Supreme Court, and so forth, right? We, in fact, know that Justice Thomas does not appear to be very favorable to rights of minorities. So it doesn't really that work, right? Our complaint about Justice Thomas is not his race, is about his perceived biases, right? That supersede his race. So I'm not sure that it's a great idea to somehow make the Supreme Court reflect the American, right? For one thing, there are way too many categories to make it happen.
Celsa, you've had your hand up for a while.
Yes, my question has to do with the recent presidential immunity decision.
Yeah.
I'm wondering what is the constitutional basis for that? What's the rationale behind that decision?
Professor Chan, if you're done with your slides, could you stop sharing, please?
Sure.
Thank you.
I actually did give a presentation on this a couple of weeks ago. It's worthy of an entire discussion. I would say that the decision came about in the same way that a lot of decisions come, is by incremental decisions, right? So there was a decision called Nixon versus Fitzgerald, in which a career bureaucrat sued Nixon for his termination. And the allegation was that his termination was driven by politics. The bureaucrat had given testimony in Congress that was not pleasing to the administration, the Nixon administration. And so when he sued the administration and sued Nixon personally, the court ruled that that for various reasons, that presidents cannot be sued civilly for decisions that they make during office. Okay. And you can think about the reasons why that would be the case, right? You can easily imagine that the president can literally be sued by thousands, if not millions, of people for decisions like, decisions that eliminated entire industries, decisions to go to war that result in the deaths of innumerable soldiers, and frankly, of people in other countries, right? They suing and so forth. So that was the basis of this particular, one of the bases of this particular immunity decision. The court reasoned that we have already decided that for reasons of preventing interference of autonomy against a president, we would not allow the president to be civilly liable for official decisions. Then they reasoned that, well, to expose the president to criminal liability is even more of a damper on the president's decision-making. They'll always be making timid decisions for fear of being criminally liable. So that was kind of the ideological basis for that decision. On the criticism of it would be that it was extremely broad. It was an unnecessary decision for various reasons. I can get into it a little bit, but I might spend a lot of time doing that.
We had a question on the chat window. Can you see that again?
Shall I go to the chat or?
Well, I raised the same question in the chat.
I was thinking the Supreme Court, could you comment on the Supreme Court ethics issue?
Yeah. Yeah, it is pretty amazing that the Supreme Court had been subject to the very lightest touch in terms of their ethics. And it is certainly, it will be controversial, but it's certainly within the purview of Congress to legislate in this fashion, to say that the judges have to comply with certain ethics rules. And I think that process is being done. There are other attempted changes to the Supreme Court under the Biden administration that probably will not happen just because it requires a constitutional amendment. For example, the term limits, 18 years, that won't fly without a constitutional amendment. What else was it? Changing the size of the Supreme Court, that is something that can be done purely by legislation. There's no magic number to 9. It's been less than 9. It's been more than 9 in history. But as far as the idea about allowing each administration to picks, that may be constitutionally limiting as well.
Okay, Helen?
I have this concern about the immunity case, because it sounds to me as though the Supreme Court justices did not separate out a lot of things. I mean, I think there was somebody who set an example about the idea that an official duty of appointing an ambassador was not something he could be criminally liable for unless he accepted a bribe to appoint said person for financial gain. outside of the presidency or something like that, but they acted as though they couldn't make a distinction at all. And I thought that was very lazy of all 6 of the conservative ones.
I would agree. I would agree. Yeah, it's almost inconceivable that the Supreme Court had ruled in such a broad blanket way, and somehow failed to have more nuance. So, for example, the famous example that was given in the appellate court, one of the judges actually asked the question, do you mean that the president has the ability to order SEAL Team 6 to assassinate a political rival? And that seemed to be an absolutely absurd question. Of course, they can't do that, without actually mentioning that example. Chief Justice Roberts' decision in the immunity case, I would say, and it's not a difficult call at all. The answer to that question about SEAL Team 6 is emphatically yes. The president can do that and will not be criminally liable for that. Why? Because the first part of Roberts' decision was that in the exercise of the president's core constitutional powers, the president cannot be subject to criminal liability. You can't second guess the president under the criminal laws. Now, one of those core constitutional powers is that the president is the commander-in-chief of the military. SEAL Team 6 presumably is a member of that military, and I'll use President Biden as an example, could order right now SEAL Team 6 to assassinate President Trump, and that would not subject President Biden to criminal liability under Chief Justice Roberts' decision. Now, if that ever happened, I am sure that the result would be different, but nevertheless, that's how Justice Roberts decided. Now, there are other parts of that decision, so that would be a core constitutional power. The second prong of that test was a president will be immune from liability, either presumptively or absolutely, for any exercise of official duties, right? Any duty that they do as a president. And then the third prong of that decision was the president has no immunity for private acts, basically non-official acts.
I'd heard a comment to the effect that the Supreme Court has taken on a lot more cases lately than it did when it was, 50 years ago. And that was suggested as a reason for expanding the court, that it could more effectively rule on various topics.
Factually, that's not true. Factually, the court has taken a lot fewer cases than in history.
All right, Zim?
Yeah, I just have maybe a broader question. Looking at the Roberts called court overall, or the Warren court for that matter, do you find them to be intellectually consistent or philosophically consistent across their decisions, regardless of whether you would agree with them or not?
It's kind of hard to say. I mean, it's a very broad jurisprudence. Certainly haven't read all the cases, and it all depends on which particular principle you're identifying with. So, so conservative justices, for example, have this idea that we should have a limited government, that individual freedom is paramount, that more of political power should rest with the states than with the federal government. And judges ought to apply a very modest form of interpretation of the Constitution rather than an expansive one. So how do the conservatives live up to that? Well, as far as the idea about judges, being more narrow and modest interpretation, you can say that they failed in that respect for sure, as I have talked about. Liberals, I don't think they have ever confined themselves to the idea that they ought to stick with the original meaning, so when they act in a way that is more expansive according to their own ethics, I don't think they're being disingenuous about it or hypocritical. They're just doing what they believe in. It's a complex question. I mean, it's worth a long 2-hour discussion about all kinds of different things. I would say though that, and this is something I tell to the students, judges are, they're pretty intelligent people. They really know the law very well. It would be a very incompetent lawyer not to be able to clothe your decisions in some kind of legal righteousness, right? There's so much to work from. There's so many decisions from the past. There's so many dissenting opinions to draw from. There's so many ideologies to claim that the Constitution instantiates. Thomas, for example, is very, very fond of citing his own opinions. Even if he was in the sole minority of opinion, he will cite himself as authority, right? So with that kind of leeway, to write your opinions, they're going to sound very, very strong. They're going to sound very convincing. You read their opinions, they say, "Oh yeah, okay, I get it." So it's hard to pin down to say, you're being disingenuous when they have to show their work, and they're pretty good at showing it.
Okay. Hi, Leland. I wanted to ask a question because I have a lot of confusion around certain cases. I've never had anybody as knowledgeable as you speaking on the subject of what is it that could be done to alter the interpretation of Citizens United. For example, as I understand it, there's allowed to be some limits on expenditures for candidates, but it seems like that's the fundamental problem we're having right now. And is there, having read it, I read it years ago. I read the whole opinion. And the Supreme Court did have a few ins and outs about how you could get around this, how you could have limitations, as I recall. But what do you recall about it?
Okay, so Citizens United was a decision in which you had a corporation that was supporting a form of electioneering communication right before the election with Hillary Clinton. This is not 2016, but I think 2012, as I recall. And so under the McCain-Feingold rules, you cannot engage in certain political speech within 30 days of a primary and 60 days of a general election, right? The idea there is that, the Congress decided that it was inconsistent with the idea of political persuasion to allow moneyed interests to unduly influence the elections without limit within a certain time period of an election. Okay. So that was passed by Congress, right? This is a rule passed by Congress. And what the Supreme Court said was that, we have in this country the idea of free speech, and free speech, if it means anything, means free political speech, right? You cannot, as a president, for example, say, I'm going to squelch all criticism during my administration, or even worse, well, not worse, but during an election, and prevent anybody from criticizing me while I'm running. That's something that other third world countries do, not the United States. But what Citizens United argued was essentially that hey, corporations are merely collections of people. And by the way, it applies to labor unions too. It's not just corporations. Okay. So what Justice Alito, as I believe that he wrote his decision, he said that you cannot have restrictions on speech based on who the person speaking is, who the speaker is, right? You cannot have a speech that says, Chinese people can say this, but Japanese people can only say this. That's content-based restrictions. You can't allow that in the First Amendment. And Alito also argued that under the ideals of free speech, the more speech, the better, right? And if you don't like the speech, you should speak more and oppose it. So based on those principles, the Supreme Court for the first time said that corporations, again, being collections of people, and labor unions being collections of people, can use their treasuries, right, to use their corporate wealth, their labor union wealth, union dues, in order to spend money for political purposes, except that you can't just give it straight to the candidate, right? You can spend it into, say, you should vote for Hillary, you should vote against Hillary, but you do it on an independent basis. As long as you don't coordinate with the candidate, you can spend $1 zillion on it, and that's protected under free speech. So that's Citizens United. So as long as the Supreme Court says that corporations have this ability to engage in political speech and spend money doing it, there's no way to reverse that. Now, of course, you can have a new crop of judges that go into the Supreme Court who say they'll overturn Citizens United, right, by saying something like corporations aren't people, and that would do it.
Right. I had a question about, I forget the case that was ruled on, but there was a ruling a few months ago that someone had been convicted of accepting a bribe while in office. He had given large contracts to a friend. Pardon?
Senator Menendez?
I don't know if it was him, but he had accepted a gift of $16,000, and that was ruled a bribe. And my understanding is that the court had ruled that it wasn't really a bribe. He referred to it as a gratuity, which seems kind of odd.
I'm sorry, I don't know that case.
You don't know the case?
Is it a federal officer or local state?
I think it was a state officer.
I'm sorry, I haven't heard of it.
Okay.
But what's your question, though?
I was just wondering if you're familiar with the case and if there were any limits on that, the size of the gratuity. And
no, you can't.
But if you're not familiar with the case,
yeah. But for any conviction, you need to look at the whatever law is applied, and you have to fit the facts within the wording of the law.
Okay, it was the overturning of a conviction, but Oded, I see your hand up.
Yeah, I have a question about freedom of speech.
Yeah.
Does everyone have the same amount of freedom of speech? For example, somebody parade in DC saying Kill America have speakers of 200 watts. So I take another speaker of 200 watts and say, leave America. Now we have create big cacophony, big noise altogether. That means, is my freedom of speech is better than other freedom of speech? Or it's the same, so everyone can speak as loud as he wants?
Well, this is a whole class worth of discussion about what does free speech mean. But the general rule is that the government has no ability to squelch speech except for many exceptions. Like, for example, if you're on a campus, right? The campus does have the ability to place time, place, and manner limitations on free speech. So if you have a class that's going on, the professor's trying to talk, you don't have the free speech to stand up and say what you normally can say in the quad, for example, right? That's a time, place, and manner restriction of free speech. But generally, the rule is that no, the government has no ability to place restrictions on the identity based on the identity of the speaker, nor based on the content of the speech. There are exceptions about child pornography, about incitement, and things like that. But so if you have a more narrow question, I'll be happy to answer it.
It means it's not government. It's one group want to talk, to speak, and the other group want to speak in the same amount of loudness and the same location. Does one group have better privileged than the other.
Yeah, believe it or not, that is not a free speech issue. It's not a First Amendment issue. The First Amendment says Congress shall make no law, abridging the freedom of speech. Right? It doesn't say that you have the ability to speak vis-a-vis some other private person. Right? If your mother, let's say my mother, prevents me from speaking out my tone, that's not a free speech issue, because my mother is not Congress, or it's not the government.
Paul?
I'm still not clear about this recent decision of the Supreme Court regarding in-office presidents, not that you can't prosecute them for certain violation of certain laws. Does that include state laws? If the president's out driving in his own car and exceeding the speed limit, could he be arrested, he or she? Are there other exemptions to that, or is he or she, the president, in-office president, simply exempt from any other laws?
So we're talking about criminal laws.
Yes.
Criminal immunity. So the three categories that the Supreme Court decided. One was the president is absolutely immune from decisions made pursuant to the president's core constitutional powers. The second is that the president has either absolute or provisional presumptive immunity for any acts taken officially, right, as president. The third is that the president has no immunity from non-official acts.
What was the last one?
Non-official acts. So, for example, President Trump was convicted 34 counts of evading state tax laws, right, based on the Stormy Daniels payout. Well, that doesn't seem to be related to any official duties. So, nor was that, and that was probably taken before he was president. So, that would be an example of probably a non-official duty, non-official act.
Let me pose another one. Suppose a sitting president, after the election, should determine that the inauguration of the person who was elected would constitute a clear and present danger to the good of the republic, should that person be inaugurated and enter the office.
I'm sorry. So, if the sitting president who just got unelected should interfere with the incoming president's inauguration?
Well, by killing him.
The
judgment is.
Yeah, the manner of answering that question would be: can it be argued that the assassinating president's official duties include something about interfering with the inauguration of the following president? If you can color your argument to fit that action within this idea of an official duty, then what the decision says is that there's either absolute or presumptive immunity from criminal prosecution for that act.
Okay. So if a yes or no answer is possible, if in the
it falls in the same kind of thing with the SEAL Team 6, right? So Trump, for example, right, he's been arguing that, this is not election denial or interference with the transition of power. I'm merely trying to enforce the integrity of the elections, right? That's what he says. So his lawyers would say something like, he has some kind of official duty to ensure the fair administration of elections. And if that is deemed to be an official duty, then under the decision, he could argue that he's not subject to criminal liability for exercising those duties.
Okay.
I was thinking about free speech. It seems to me, basically, you're free to say pretty much anything you want as long as you're not advocating a crime. You can even advocate that something not be made a crime.
No, you can even advocate that you ought to do something that is criminal, as long as you're not inciting and causing imminent physical danger to another
You can
person.
do it, but if the crime is committed, you may find yourself in trouble.
If you commit the crime, yeah, but talking about it is not illegal.
Okay. Does the subject of hate crimes come into play here somewhere?
Yeah, I mean, hate crimes are essentially additions to criminal penalties if you can prove that you not only killed somebody, but you killed somebody because that person was, a woman, for example. That would be a hate crime. So, I mean, we have those laws. They've been defended and so forth. So,
Okay, Zim?
Yeah, what about commercial speech?
commercial speech occupies a somewhat less protected form of speech. So you have advertisements, for example. I'm not sure you've all seen commercials in which, there's an advertisement for some drug, and then there's like somebody talking really, really fast. So this drug can kill you and cause you impotence and high blood pressure, blah, 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 blah. Please talk to your doctor. All those are required under the FDA rules. And you can say, well, you can't do that. That infringes on, these companies' speech. Well, the commercial speech is considered considerably less protected than political speech, for example.
Okay, Dana.
With regard to the remark about if someone just says they're going to kill somebody, they can't be prosecuted until the act is carried out. But I thought of, with therapists and psychiatrists and a lot of people in service jobs where they hear people making threats under certain conditions, if somebody says they're going to kill somebody, I believe some of them are legally required to report that.
Yeah. This is the reason why the free speech class could take the entire year. So, so something related to what you said, attorney-client privilege, right? Attorneys generally have no ability to divulge the confidences of their client. But if the client is, you know that your client is about to commit a crime, that's an exception. So you have the duty at that point as a lawyer to actually convey that to authorities and so forth. What else? You talk about intentions. Same with psychotherapists. Right, psychotherapists have some requirement to report speech in that sense as well. Oftentimes people who have certain fiduciary duties over individuals have also duties to report in order to help the person, for example. I'm talking about elder care, ombudsman, people like that.
Okay, we've got a few more hands up and we're running out of time, but Jerry.
Yeah, you mentioned the ERA some time ago, and I think you said that it did not get 3/4 of the states. Actually, it did get more than 3/4 of the states, although some states revoked their agreement. So I don't know if there, at any particular time that there were 3/4 of the states were in agreement. But I did see this article that argued, actually, it did pass, and basically it just required some mid-level official in the government to say that it passed, and then it passed. You know about that and how correct it is?
I haven't followed it, I have to say. Yeah, my general point there is just to illustrate how difficult it is, to in order to have progress in the law and the Constitution, that we have to rely on the amendment process as opposed to just letting judges, exercise some degree of discretion. Again, the risk is, you might give that discretion to a Justice Thomas as opposed to Ruth Bader Ginsburg.
Greg.
Okay. I was wondering, given the concerns about ethics and partisan bias on the court these days, are there reforms that you would recommend to reduce the existence or appearance of such problems on the Supreme Court?
Certainly, the easiest low-hanging fruit would be to have these ethics rules, right? The ones that are hitting now, Justice Thomas, for example, pretty egregious in my view. And Justice Alito's, his actions are more, I would say, bad discretion rather than, ethically questionable. And I'm talking about, the use of certain flags used by the Jan 6, protesters and things like that. That just shows bad form, right? That's like an umpire wearing a Giants, logo on their uniform. That's that kind of thing. So that, yeah, I think I would say the low-hanging fruit definitely is to institute some kind of reasonable ethics rules.
Anna?
Yeah, I had back to the question of people making threats to people. I'm sure I heard a policeman tell me one time that actually just making a threat is a prosecutable offense. That it is a crime to threaten someone's life, and that if someone does that and they're witnesses or whatever, they can be prosecuted for that. Is that true?
Again, so there are definitely rules about making threats against a minibus driver, making threats against politicians, on their life. Those certainly are true. Can you be prosecuted by saying to somebody, I'm going to injure you or something like that? A little more questionable, very, very questionable, so.
I understand, and I may be wrong, that there are rules that you can't arrest a member of Congress while he's in office. That his job as a member of Congress takes precedence.
If you don't mind, I'm going to look at. Yeah, there is a provision that talks about protection. You cannot be held liable for speeches, for example, made in Congress. Let's see if I can find text.
I think it actually referred to preventing him from sitting in Congress. And
yeah. Rather than try to research that, I wasn't prepared to actually answer the question. So we're getting a bit far from the topic. Certainly you want to have protections. You don't want to have legislators, being held liable for doing their work for the country, right? You may hate that person, what that person is saying, then don't vote for them, right? Get them out of office that way. That's really the way to try to put some limits on such a person. But I don't think we want a system in which an ordinary citizen can go to the Supreme Court, for example, and try to censure some position taken by a legislator because you don't like what the legislator is saying, right? That's not very good. There's some separation of powers problems with that as well.
yeah, I suppose there's always a problem in interpreting anything in writing. I'm thinking of the phrase of Congress shall not pass any law restricting the right to bear arms, but obviously that doesn't apply to people who've been convicted of an attempted murder. They've always been restrictions on that. It's up to a reasonable interpretation.
Well, even if, even for rights that are clearly written in the Constitution, no right is absolute, right? Speech right is not absolute, right? You cannot, it's illegal to publish child pornography, right? Incitement, those are restrictions, yeah. And Second Amendment, that's another talk. The Second Amendment basically says something like the presence of a militia being, important for a free state, the right to bear arms should not be infringed. So it's kind of weirdly written.
Yeah, it seems to present a rationale for the freedom, which seems to be extended beyond that.
Well, I mean, for longest time until 10 years ago, the Second Amendment had been interpreted in connection with that preface, right? Mm-hmm. The importance of the militia. So it has never been interpreted just freestanding. The right to bear arms is sacrosanct. So but this gets to this whole question again about the discretion of judges. Right? Do you want judges to be limited to how things were interpreted 250 years ago? Or should it be interpreted based on, today's values, right? Now, the conservatives would say, in today's values, we think that the Second Amendment is very, very important, whatever, 80% of people own guns or whatever they say. So they'll say, so judges ought to have that liberty, the discretion to interpret the Constitution in a more modern way, right? Now, many of you may disagree with that, and I disagree with that. But would you also say that, the Warren Court should never have made abortion legal because the abortion was never found in the Constitution, right? So it really comes back to the question: who decides, right? Should it be the policymakers, or should it be judges basically thinking that their values are correct? And it's one of these questions that are evergreen, right? It's always the question, right? And I find it that my students kind of struggle with that idea of, is it more important to be consistent with the principle that Congress makes the policies and the judges merely interpret? Or should we forget all of that principle? Let's just go for results, right? We want good results. But then the problem is, well, what is good?